All right, ladies and gentlemen, I guess we're now ready to begin our first session here at the 2024 ICAO Legal Seminar. The first session is titled ICAO's Work in Legal Field, and this will be led by Mr. Michael Gill, Director of Legal Affairs and External Relations Bureau at ICAO, and also joined by Mr. Andrew Opalot, the Legal Officer of Legal Affairs and External Relations Bureau at ICAO. Let's welcome both of the speakers to the stage with a big round of applause. Yes, for this session, we are to welcome Mr. Michael Gill, the Director of the Legal Affairs and External Relations Bureau at ICAO. And also, another speaker that will join us is, yes, Mr. Andrew Opalot, the Legal Officer of Legal Affairs and External Relations Bureau at ICAO. Is the two gentlemen here in the room? Yes, please join us on the stage. And as we have both gentlemen on the stage, we will begin the first session. Yes, why don't we welcome both of the gentlemen again with a big round of applause. And of course, for the first presentation, we're going to have Mr. Michael Gill on the podium to have the presentation. So, sir, please.
Thank you very much for that warm welcome. Good morning, ladies and gentlemen, excellencies, distinguished ministers and representatives to ICAO. Dear colleagues, it's an absolute honor and a pleasure for me to be here with you this morning. And I do want to start by thanking our colleagues at the Ministry of Land, Infrastructure and Transport of the Government of the Republic of Korea for the invitation to be here and for their extremely generous welcome and the strong support that they've given to ICAO in the organization of this event. As has been said, the legal seminar has now been running into its seventh iteration, and the event continues to go from strength to strength. You can see the level of interest for this meeting by the number of us here in the room and also joining online. And I think it's a testament to the support and the investment that the government of the Republic of Korea have given to this event and to the activities of ICAO in the legal field generally. So it's a real pleasure for myself and the rest of my colleagues from the Legal Bureau to be here with you, and we're looking forward to spending time with you in the coming days. What my presentation is intended to do really is give an overview of the activities of ICAO in the legal field, particularly since the last session of the ICAO Assembly in September and October of 2022, and the work that that has been undertaken in the last 2 years as we prepare for the next session of our legal committee in June of this year in Montreal, as well as the following 42nd session of the Assembly in the autumn of 2025. So what I'm going to cover are an overview of ICAO's policies in the legal field, the background and current activities of the legal committee and our work program. I wanted to say a few words on the issue of the settlement of disputes by the Council of ICAO, as that's becoming an area of particular focus, and then hand over to Andrew Opalot to move forward with his part of the presentation. Now, just by way of background, there are many ICAO experts in this room, many people who've worked for a number of years with ICAO, but for those who are not familiar with the organization, just a few words of introduction. ICAO is a UN specialized agency. We were created by the Chicago Convention, which was adopted on the 7th of December 1944. Interestingly, the Chicago Convention was adopted before the end of World War II and indeed before the adoption of the UN Charter. Now, the Convention provides not just the constitution of the organization itself, but of course also sets out a whole range of substantive rules governing international civil aviation. But the Convention's only been amended twice as far as the substantive rules governing international civil aviation are concerned. And I think that really demonstrates that the basic principles governing international civil aviation have remained largely unchanged since 1944. We today have 193 member states. The last member state who joined was Dominica in 2019. And as the Secretary-General noted earlier, this year marks the 80th anniversary of the adoption of the Chicago Convention. It's a significant milestone. I think, bears witness to the strength of the drafting of the Convention itself, as well as the commitment to our member states, to our organization over those 80 years, and a number of events will be taking place in the course of 2024 to mark that. The ICAO Assembly defines the strategic objectives for each triennium, and currently the strategic objectives of the organization are shown on this slide. Aviation safety, aviation capacity and efficiency improvements, enhancing civil aviation security and facilitation, and we heard earlier that this year is also the 75th anniversary of the adoption of Annex 9 to the Convention on facilitation. A further strategic objective, of course, is fostering the development of a sound and economically viable civil aviation system. And then finally, to minimize the adverse environmental impacts of civil aviation activities. Now, again, as the Secretary-General noted this morning, there is work underway at the moment to review those strategic objectives and ensure that they're fit for a purpose for the coming decades of the organization. And one of the areas which we're looking at is whether to include the rule of law, strengthening the law and the legal system governing international civil aviation and our rules-based system as a strategic objective for the organization itself. And those discussions are ongoing within the Secretariat and, most importantly, within the Council. So that's the overall strategic plan for ICAO. But specifically in the legal field, the ICAO Assembly defines the policies of the organization, and in the legal field, those are contained in Assembly Resolution A41/4. Essentially, that is a consolidated statement of ICAO's policies in the legal field, and it is updated at every session of the Assembly, but essentially sets out what ICAO's policies are. And so, for example, that resolution I mentioned reaffirms the important role of law in the avoidance and resolution of conflicts and disputes amongst the nations and peoples of the world. There are other three specific appendices to that resolution which I think are important to note also. Appendix C to our consolidated statement deals with the ratification of international air law instruments, and the next presentation by Andrew Opolo is going to address that very topic. Essentially, through that Assembly resolution, all states are called upon to consider becoming parties to the various ICAO air law treaties. Appendix D of our consolidated statement deals with the teaching of air law. It's a really fundamental activity for ICAO. Essentially, we as a Secretariat have been directed by the Assembly to take any possible actions not only to promote the teaching of air law, but to promote the dissemination of the knowledge of air law all around the world. And I think it's a really crucial activity to encourage the next generation of aviation professionals and aviation law professionals in particular. Appendix G of our consolidated statement deals with the enhancing the capacity of states to implement air law treaties and to update national laws and regulations. And that aspect of the resolution really confirms the important role that civil aviation legal advisors and air law practitioners generally play in supporting states and the industry in implementing international air law treaties, updating national laws and regulations to give effect to national policies. Interestingly, the resolution asks for member states to support the work of ICAO in enhancing the capacity of the civil aviation legal advisors in our member states, and that's a very important part of our work. And events like this, I think, really support that. Now, turning to the ICAO Legal Committee itself, the Legal Committee was established in 1947 by the first ever session of the ICAO Assembly, and it's open to all member states. It's not a committee of limited membership. The committee is somewhat unique in the overall ICAO governance because it's a body that was created neither by the convention itself nor by a decision of the Council. It was specifically established by the first session of the ICAO Assembly. But as I said, participation is open to all member states. The committee meets as and when necessary, when there's a specific decision that needs to be taken or a specific piece of work which needs to be reviewed. But generally speaking, over its history, the committee has met once every 2 years. In our mandate of the Legal Committee, there are various specific functions advising the Council on the interpretation or of any amendments necessary to the Chicago Convention, making recommendations on matters of public or private international air law, preparing drafts of international air law treaties. And on that point, it should be noted that the Legal Committee in its existence has contributed significantly to the development and the unification of international air law. Under the committee's auspices, some 24 international treaties have been prepared in the fields of aircraft finance, airline liability, and aviation security. And so the Legal Committee will continue to play that strong role in the development of international air law. Now, what do we have on our work committee? The work programme of the Legal Committee is defined by the Council, and we currently have 8 items, and you'll see them on this slide in the order of priority. Tomorrow you're going to have a full briefing on item number 1, which is the review of the rules for the settlement of differences, so I won't go into that particular topic in too much detail. In a moment I'll talk about the function of the settlement of differences generally by the ICAO Council, but the progress on the review of the rules will be briefed tomorrow. But just to say a few words on the other top priority items 2, 3, and 4, which I think will give you a flavour of the work currently underway within the Legal Committee. As I said, our upcoming next session of the Legal Committee will be from the 25th to the 28th of June in Montreal, and the committee essentially will consider the items on the work programme, but in order of priority, with more focus given to the top priority items. I did want to say that at the end of this session of the Legal Committee, we will elect a new chair and a vice chair who will serve for 2 sessions of the committee. And I think it's an appropriate point in time to recognize the significant contribution of the current chair of the Legal Committee, Ms. Sue Hei-Tan from Singapore, who has served in that position since September of 2018. Sue Hei-Tan will be appearing on our program tomorrow and is well known to many of you, but she has made a huge contribution to the work of the organization, a huge contribution to the ICAO Legal Committee, and to the cause of international air law generally. And so we all owe her a huge debt of gratitude. What about the substantive topics then on the Legal Committee agenda? I just wanted, as I said, to mention a handful of them. Our top priority item 2 relates to the legal aspects of unmanned pilotless aircraft, and there will be a specific panel discussing that topic at this seminar, tomorrow. As you may be aware, the framers of the Chicago Convention recognized even then, some 80 years ago, the potential for the emergence of new technology, and there is already in the Convention, in its Article 8, a provision dealing with pilotless aircraft. That issue was then included on the work program for the Legal Committee in 2013, because I think it was recognized that pilotless aircraft, RPAS, drones, UAVs, however you want to term them, were developing at a rapid pace, and it was important that the legal framework kept up with the technological and operational developments. And so the Legal Committee at that time established a working group, and essentially the key legal topics to be addressed are looking at the international legal aspects of pilotless aircraft operations and how they should be integrated into the civil aviation system, identifying items for consideration and possible legal solutions within the framework of ICAO's ongoing work, looking at legal measures to support the implementation of the international regulatory framework which is necessary for a pilotless aircraft, and then looking at legal issues arising from newly emerging unmanned pilotless aircraft technology systems and applications like unmanned aerial taxis, the carriage of cargo, and related liability concerns. So that work is ongoing. There is, as I said, a working group of the Legal Committee which is set up two subgroups, and we look forward to hearing reports from those groups at the upcoming session. And as I said, tomorrow there will be a specific panel in this seminar looking at new mobility challenges and the aviation legal perspective. Another item on the work program of the committee relates to Article 12 of the Chicago Convention. As you may be aware, under Article 12, the state of registry of an aircraft is responsible for ensuring that the aircraft complies with the rules and regulations relating to the flight and maneuver of aircraft in force wherever such aircraft may be, and the prosecution of all persons violating those rules and regulations. Since 2019, this topic has been on the work program of the Legal Committee. The overall objective is to undertake a study of the current implementation of Article 12 by member states, as well as to identify the means and the mechanisms for states to support and enhance implementation. So the main output we're looking for on the topic of Article 12 is to develop ICAO rules or guidance recommendations aimed at assisting states to enhance the implementation of their obligations under Article 12, the terms of which aren't noted on this slide. The committee is also looking at the development of a mechanism which would allow for the timely exchange of information between states following a violation of the rules of the air in order to support compliance with the obligations under Article 12. And perhaps that mechanism will take the form of a web portal for the exchange of information between states. But it's a key piece of work that the Legal Committee and the relevant task force is undertaking. We issued in December of 2022 a survey to member states. The main purpose was to elicit responses concerning the existing mechanisms and measures and challenges for states in performing these obligations under Article 12. And you'll see on this slide the split in the percentage of states that have established laws or regulations for the implementation of Article 12. Some 86% have established laws and regulations regarding prosecution for violations of the rules of the air, and you'll see the other split of the responses to the questions that that survey elicited. So the committee will consider at our upcoming session progress on the work that's been carried out by the task force so far, and then potential next steps in that work. The other area on the work programme of the Legal Committee I wanted to mention relates to acts or offences, including cyber threats that may not be adequately covered by existing air law instruments. Now, of particular concern here is the implementation of the Montreal Protocol of 2014. This relates to the legal aspects of unruly and disruptive passengers, which can have a direct relation to cyber threats. And there's been a lot of work going on within ICAO on this topic. In 2019, we published the manual on the legal aspects of unruly and disruptive passengers, and since then we've continued to monitor and respond to inquiries relating to the Montreal Protocol of 2014. You're going to hear more detail on the promotion of the Montreal Protocol of 2014 later on in this seminar, but it's an important development in protecting international aviation security. We should also note, with regard to the cyber security aspect, that ICAO continues to promote the Beijing 2010 instruments, which many of you will be aware of. Those have a specific application to cyber attacks against civil aviation and are important international air law instruments which we need to continue to promote. So those are items currently on the work programme of the Legal Committee, and which will be discussed at our next session. Now, there are 2 points which are not on the work programme but which may well end up there, which I did want to mention. Firstly, relating to the Convention on the Marking of Plastic Explosives adopted in 1991, the famous MEX Convention. Just by way of background, the MEX Convention was adopted following a series of major air disasters in the 1980s, Air India in 1985, and the Lockerbie Pan Am disaster in 1988, where explosives were found to have been placed on board aircraft, evading detection by the screening processes which were in place at that time. Now, during the most recent session of the Council in March of this year, the Council has requested that the implementation of the Convention on the Marking of Plastic Explosives should be considered by the Legal Committee at its next session. The reason for it is quite simple. Under the Convention, the Convention establishes a commission to evaluate technical developments relating to the manufacture, marking, and detection of explosives. And that commission is appointed every 3 years by the Council, and the commission is entrusted with proposing amendments to the technical annexes to the MEX Convention. However, over the years, the work of the Convention has somewhat lost its relevance because technology and methods for screening have advanced, enabling a detection of plastic explosives by other means. So on the one hand, there is an obligation on the Council to proceed with the nomination of the Commission, but in reality, the work of that Commission has largely been overtaken by technology developments and does not have any particular purpose. So we're appointing a commission which has a limited scope and purpose. And so the Council has asked the Legal Committee to consider looking into this issue so that the committee can either undertake an evaluation of potential solutions as to whether an amendment is required to the Convention in order to redefine the roles and the functions of the Commission, or alternatively to terminate the functioning of the Commission on the basis that it's fulfilled its initial mandate. So that will be a topic raised at the Legal Committee. Another issue which is not yet on our work programme is that relating to data protection and international carriage by air. This is a topic of key concern to the industry, and I'm delighted that you'll hear more on this from my colleague Leslie McIntosh, representing the International Air Transport Association, IATA, and the airlines, and she'll highlight exactly why this is such a topic of such concern for the sector. We held a joint seminar with IATA in September of 2023, really just to highlight the complexity of existing national data protection laws and the importance of protecting personal data when it's transferred across jurisdictions. Now, in the past, a lot of ICAO's work in this area has related to API, Advanced Passenger Information Data, and PNR, Passenger Name Record Data, which is addressed in Annex 9. But we are understanding that this issue is of broader concern and needs a more holistic view. So this is an issue which we'll hear more from the industry and indeed which the Legal Committee will give consideration to. So as you can see, we have a pretty full agenda for our June session, but there are many interesting and varied topics that the Legal Committee will consider. Moving on from the Legal Committee itself, I did want to say just a few words about the settlement of disputes function by the Council of ICAO. As I said, my colleague Yao Nyampong tomorrow will go into a lot more detail about the process of revision of the rules of procedure for the settlement of disputes. But briefly, I wanted to mention what the function of dispute resolution by the ICAO Council relates to. Article 84 of the Chicago Convention essentially entrusts to the Council a function in the settlement of disputes between contracting states. Under that provision, any disagreement between two or more contracting states relating to the interpretation or application of the Convention or its annexes that cannot be settled by negotiation shall be decided by the Council on the application of any state concerned in the disagreement. Decisions of the Council under Article 84 may be appealed to the International Court of Justice, or if the parties can agree, to a separate arbitral tribunal. Now, we do have a set of rules, a separate set of rules of procedure for when the Council is seized of a case under Article 84, but those rules were adopted in 1957, and as I said, there is a process in the Legal Committee underway to review and update those rules of procedure. Now, within the whole of ICAO's history, we've only had 12 cases brought before the Council for consideration under Article 84, and in none of those cases has the Council actually had to rule on the merits of a dispute, because all of the previous disputes have been settled through mediation or negotiation relying on the good offices of the President of the Council. But since 2016, we've had 6 cases presented to the Council, 3 very recent cases which you'll see on this slide, which have been filed since 2022, Australia and the Netherlands and the Russian Federation in 2022, which relates to the downing of flight MH17 in July of 2014. And then in February of October of 2023, the Russian Federation and 37 member states relating to allegedly unlawful and unilateral restrictive measures imposed against the Russian Federation in violation of the Convention. And then in January of this year, a matter referred by Canada, Sweden, Ukraine, and the United Kingdom against Iran relating to the downing of flight PS752 in January of 2020. And we understand that another case will shortly be received by the organization under Article 84. Now, I wanted to mention, because as I said, this is the level of activity under Article 84 matters has increased significantly. It shows that states are, I think, increasingly seeking the avenue of Article 84 as a means to resolve aviation disputes. I also think, frankly, that shows the confidence that our member states have in the robustness of the Article 84 mechanism. They recognize that there is a way for them to resolve disagreements through the Council, while still allowing the crucial work of ICAO and the rest of its fields of activity to continue. And so I think this increasing use of Article 84 is a good demonstration that our states have full confidence in the robustness of that mechanism and its ability to bring solutions to disagreements that they may have. As I draw to a close, I just wanted to highlight one thing which many of our states may not be aware of. There is a portal on our secure ICAO website, which is administered by the Legal Bureau, and it contains a lot of very important information allowing contact between states and ICAO on safety and other aviation matters. A number of states have included on that page information about the respective legal advisors in the states, and we're encouraging all of our member states to submit and keep the information in that portal up to date. If you need any further information on that, please don't hesitate to reach out to one of the Legal Bureau or the Legal Bureau address in Montreal. So let me conclude again. Thank you for your attention to this presentation on the work of ICAO in the legal field, what we've been trying to achieve since the last session of the Assembly, and anticipating the upcoming 39th session of the Legal Committee in June. We hope to see many of you in Montreal in June for what we hope will be a successful Legal Committee meeting. I wish all of you a very productive seminar. I wanted to close in thanking again our hosts in the Government of the Republic of Korea, all of our sponsors, but particularly to all of you for your participation, your kind attendance, and we look forward to the interaction with you in the coming 2 days. Thank you very much for your attention.
Yes, thank you very much, Mr. Michael Gill, for the presentation. He has talked about the progress over the last assembly and what we can expect this June at Montreal. And of course, he went over the ICAO's strategic objectives as well as the work programs and the policies in the legal field. Moving on, we would like to invite Mr. Andrew Opolot to the podium for his presentation. Let's welcome him with a big round of applause.
Good morning, all. I would like to thank the Ministry of Land, Infrastructure and Transport of the Government of the Republic of Korea for the invitation to be here today. This is my third visit to Korea since 2015 to facilitate at this event, and it's therefore a great honor to be invited again. Samita. The ministers and the Secretary General this morning all emphasized the importance of states jointly seeking positive change, and treaties represent the best example of nations coming together to forge consensus towards a common objectives when they adopt treaties in a spirit of give and take. The world needs to see this universal approach followed also in the process of ratification and implementation of the adopted treaties. As has been emphasized, a unified global legal framework contributes to the orderly and safe development of international civil aviation for global peace and prosperity. So my goal today is to recall how good these treaties are for the states and for the civil aviation industry, and what ICAO is doing to help states consider those benefits and undertake the ratification process, and how agencies of the state and the aviation industry can participate. First, I'll just give you the context under which treaties are adopted at ICAO. There are two different paths followed in the lawmaking process. The first path relates to amendments to the Chicago Convention, and this path is governed largely by Article 94 of the Convention. Article 94A reads that any proposed amendment to the Convention must be approved by 2/3 vote of the Assembly and shall come into force in respect of states which have ratified that amendment when ratified by a number of contracting states specified by the Assembly. The number so specified shall be no less than 2/3 of the total number of contracting states. And this is where the problem lies with these amendments in this last sentence of 94A. Although a number greater than 2/3 has never been specified by the organization, but as its membership has increased, this becomes increasingly difficult. So with a membership today of 193 states, any amendment adopted would need 128 ratifications. So that is a steep slope to climb, even in the best of circumstances. The vast majority of amendments to the convention have been thus far institutional in nature, relating to administrative and procedural matters such as membership, budget, permanent seat, and official languages. In substance, the convention has only been amended twice since 1944, which is a testimony to how durable that framework has been. And of course, this will be part of the discussions later tomorrow, how the convention has worked over the last 8 years. But relating to the two principal substantive amendments, the first one being the amendment introduced by Article 3 bis, and it concerns the prohibition of the use of weapons against civil aircraft. It was adopted by the 25th Assembly of ICAO on 10th of May 1984 in the aftermath of the shooting down of Korea Airlines flight KL007 over Russian airspace on its way from Anchorage in the US to Seoul. The second amendment, Article 83 bis, was adopted in 1980, and it concerns the transfer of registry responsibility, set of registry responsibilities on leased and chartered aircraft. This was necessary to ensure there's continuing oversight, safety oversight, where an aircraft operates mostly out of the state of registry for long periods of time, so certain responsibilities are transferred through an agreement to the state of the operator. This is the curve that shows you the process of adoption of a treaty, which starts generally with the inclusion of an item on the work program of the legal committee, as Mr. Gill has just described. And as you've heard, this work program will be reviewed by the legal committee meeting in June. So from inclusion of the item on the work program, the item progresses through study groups or working groups of states, and then this is escalated onto a subcommittee and with the input of a rapporteur, and finally the council, when there's a draft instrument, the council will convene a diplomatic conference. All states can participate in this diplomatic conference. The Legal Bureau, of course, is involved in supporting the process of all these organs. This category of international air law instruments do not require the 2/3 majority that is in place for the amendments to the Chicago Convention. The diplomatic conference determines the minimum number of parties required to achieve ratification, and we have had over the years requirements from as few as 2 parties and to as many as 35 parties ratifying for the instrument to come into force. Since 1947, this is the range of instruments that have been adopted in various fields, including aviation security, aviation safety, air carrier liability, and aircraft financing, which are listed on this slide. And this has been an outstanding achievement of the legal committee, whose 75th anniversary was commemorated in 2022, because the ICAO lawmaking framework has had tremendous success, with some of these treaties achieving almost universal acceptance with 180 parties or more, which is quite rare in international relations. When a state has completed the domestic requirements for the ratification of the treaty, it has to accomplish international requirements by adopting an instrument of ratification with the organization. The domestic requirements, as many of you may be aware, the treaty is considered through the executive, the administration, the cabinet, and in some states, the legislature is also involved. So once that approval is obtained and the ratification is gazetted, there has to be an instrument of ratification, usually signed by the Minister of Foreign Affairs, that has to be deposited with the depositary. And this, for most of the ICAO treaties, ICAO is the depositary of the treaties developed under the auspices of the legal committee. Instruments are deposited by transmitting the originals in hard copy by courier or physically delivering them to the Secretary General in Montreal. No electronic means are permissible at this point. When the instrument is delivered to the Secretary General, of course, this is accompanied by a ceremony with some publicity. Originals can also be sent directly or by courier or through the state's diplomatic missions in Ottawa or Washington, D.C. or New York in the U.S. In the years 2022 and 2023, ICAO has handled almost 100 depositary actions by states. As you already heard, the Assembly has passed a number of resolutions calling on states to ratify various instruments, and consistent with these resolutions on the promotion of ratification, the organization is actively promoting the ratification of 6 key international treaties, which I'm going to be sharing with you today. And these promotional efforts are going on between 2023 and 2024. So on this slide are the 6 treaties I'm referring to. First off, we have the Montreal Convention 1999, which is the convention for the unification of certain rules for international carriage by air. This treaty consolidates the rules relating to the carriage of passengers, baggage, and cargo. And the key benefit is, of course, that you have a modernized compensation regime, and I'll elaborate a bit more about what that involves. And the key takeaway here is that although the treaty has 139 parties, it is essential, because 55 other states haven't yet become party. It is essential that this is universally adopted so that these modernized rules can be uniformly applied wherever in the world a claim arises. The second set of instruments is the Beijing Convention 2010 and the Beijing Protocol 2010, of 2010, one relating to unlawful acts relating to international civil aviation, and the other, the protocol relating to unlawful seizure of aircraft. And these instruments also modernize the legal framework for aviation security by criminalizing acts that constitute new and emerging threats against civil aviation. MP14 has also already been mentioned. MP14 amends the Torture Convention of 1963, and it addresses the issue of the rising incidents of unruly and disruptive behavior on board aircraft by improving the ability of states to take jurisdiction over offenses. So in addition to the state of registry, which had sole jurisdiction under the Torture Convention, this is expanded to involve the state of landing and the state of the operator. Finally, the two protocols increasing the membership of the ANC and the Council, as has been mentioned before. I'll go through these one by one very quickly. I'm not going to teach what these provisions are all about, but just to give you an overview, starting with the Beijing instruments of 2010. As I said, they are modernizing the aviation security regime to deal with new and emerging threats. And they strengthen the capacity of states to prevent and deter the commission of those offenses and to prosecute and punish those who commit such offenses wherever in the world they may be. These new and emerging threats include acts such as using aircraft as weapons, which became apparent in the aftermath of 9/11 incident, using biological, chemical, and nuclear weapons or unlawfully transporting them by air is another offense. And also covered under these instruments is cyber attacks of air navigation systems or seizing or controlling the aircraft by cyber means or other electronic means. So I just wanted to talk about one particular threat that is not commonly discussed as an example to illustrate why this is important. And this is the threat of biological, chemical, and nuclear weapons, or BCN, which is the acronym that ICAO uses, but other UN agencies use the acronym CBRN, chemical, biological, and radiological and nuclear weapons. In a study conducted by ICAO in 2005, it was noted that biological attacks had already been observed in non-aviation environments, such as the sarin gas attack that occurred in the Japanese subway system in 1995, as well as the anthrax incidents which occurred in the United States in the late 2001. It was observed that this kind of threat could be potentially used against civil aviation at any time, but that the existing aviation security instruments did not expressly cover chemical and biological attacks. Hence, appropriate provisions were included in the Beijing instruments. This slide presents some potential scenarios for biological, chemical, and nuclear attacks, such as foodborne bioagents being introduced through in-flight catering, or chemical or biological weapons being mounted on drones and crushed into populated areas. The likelihood of some of these attacks materializing are currently assessed to be low to medium, according to guidance material issued by ICAO, particularly ICAO Doc 10108, which is the Aviation Security Global Risk Context Statement that was last updated in late 2022. However, the fact that they are assessed to be low or medium risks does not mean that they will not happen. And we just have to be prepared to play our part as the legal community when they happen by having already in place the framework to deal with them. The risk is low, but the 2023 risk profile includes the use of drones and insider threats, which can be effective for deploying BCN weapons. And we just have to reflect and remember, for example, that on the 10th September 2001, an attack using a civil aircraft, although feasible, was not considered to be imminent. Of course, the very next day, everything changed. So if it can happen, it probably will. This is a list of parties to the two treaties I just talked about. And apart from the considerations that I just cited before, it is also important to remember that the threats to civil aviation and the role of ICAO in this regard is recognized also by the UN, which through UN Security Council Resolution 2309 of 2016 calls upon states to ratify these instruments as part of the global counterterrorism strategy. So, with that brief elaboration, I would say if your state is not on this list, one suggestion I would make in order to help is that when you return home is to inquire why and where your state is in the process, and every little step such as that can help to advance the adoption, and we can all play a part. For MP14, the trend of escalating frequency of unruly passenger incidents was already existing even before the COVID-19 pandemic, which definitely made it worse, and incidents spiked in relation to enforcing compliance with public health measures. As of 10th April 2024, which is around the 10th anniversary of this instrument, we have 47 parties to this protocol, and my colleague Erica will be briefing you tomorrow about the provisions in detail during session 3. Montreal Convention of 1999 has a significant number of parties already. It's ratified by 139 states thus far, but as many as 55 states have not yet ratified, as I just mentioned. And as a result of that, we have a patchwork of liability regimes continuing to exist, with the result that it may cause confusion and complexity in determining which regime covers a particular passenger or cargo itinerary. Before 99 modernization, there were very many different instruments because there was a lack of consensus over 70 years concerning the amounts of compensation, for instance. So one of the important innovations brought by Montreal 99, apart from significantly raising the limit of compensation, was the introduction of the escalator clause, whereby the limits of compensation are reviewed every 5 years to keep them in line with inflation. The last increase took place in 2019, and another review is going on this year through the Legal Bureau and the Air Transport Bureaus at ICAO, because the treaty assigns to ICAO the responsibility to undertake this review. As a result, the issue of setting the liability limits ceased to be a matter of political debate and became a technical one, and therefore avoided the problems that had affected the regimes over the last 70 years. So the limit of liability at the moment for death and injury claims on the basis of strict liability is 128,821 special drawing rights of the IMF, which translates to around $170,000. So these limits will be reviewed and known by the year end, but in the middle of the year, states will be consulted about this through a state letter. This slide is intended to illustrate the impact of an unequal compensation regime depending on the status of ratification of the state and the itinerary of the passenger. So here you see that three passengers seated on the same flight in the same row may actually have a different compensation regime applying to each one of them. Passenger 2, under the Montreal Convention, can be compensated up to 170,000 US dollars. Passenger 1 and 3, on the other hand, have a much lower limit, equivalent under the Warsaw Convention to only $8,300, and under the Hague Convention, just $16,000. So you can see how this unbalanced situation creates complexity and lack of equality in the handling of compensation claims, and this will only be solved by universal ratification so that we can have a level playing field. So the 55 remaining states can help make this happen. And just to mention that the MC99 also facilitates the use of electronic airway bills, which are an important tool for international trade. Finally, the two protocols amending the Chicago Convention and increasing the membership of the Council and the ANC. In the case of the Council, to ensure better representation of states within the Council, and for the ANC to draw on the expertise of more commissioners. Being elected to the Council, of course, enables the state to be more directly involved in ICAO's work. So once this instrument takes effect, there will be 4 additional seats in the Council to be allocated. As of 5th April, these protocols had been ratified by 93 states, so we have 35 more ratifications to go. And the Council and the organization are particularly pushing for the ratification of these treaties so that they become effective before the next session of the Assembly in 2025, thereby allowing the election of 40 Council members, which is 4 more than the current 36. Resources to promote ratification are available at ICAO to states, and one of these is the ICAO Treaty Collection website, which contains administrative packages which can help you develop your proposal to your administration in the state to support the ratification. It includes a model instrument of ratification as well, and gives a background and summary and benefits of the treaty. This is available on the public website of ICAO on a portal which is under the legal bureau. Additionally, ICAO is always ready to provide assistance to states during the process. If you have any questions, you can contact the Legal Affairs and External Relations Bureau at that email contact provided over there. We are happy to answer questions. We are happy to review your draft instrument. Before you submit it, it can be unfortunate if you send an instrument to Montreal already signed by the minister and it contains an error, and then we have to come back and tell you to correct it. I don't know what you would tell your minister in that case. So you're welcome to take advantage of this informal review process. These are some of the activities that have been undertaken by the organization to promote the ratification. Legal seminars such as this one, the International Air Law course. I'll speak about participation at DGCA meetings in due course, and also the Civil Aviation Legal Forum. I'm not sure that Mr. Gill mentioned the next event of the Civil Aviation Legal Advisors Forum will be announced very soon, but I think some of you informally know that it will take place in the United Kingdom this November. There is sometimes some confusion about whether the CAAs are concerned with the matter of ratification, because it involves very many state agencies, Ministry of Justice, Ministry of Foreign Affairs, and the legislature. And I'm here today to tell you, having worked in the CAA before, that the CAA play a very crucial process as far as aviation treaties are concerned. They can be the champion in the state to drive the process, to advise the government and make proposals through the apparent ministry, and to coordinate with the agencies I just mentioned, undertake consultations with stakeholders and also to coordinate with ICAO for any assistance or clarification. We tried a different approach as well to go to high-level meetings, meet with DGCAs or ministers, and present to them the information that I'm sharing with you today. And during 2023, we went to 5 different regions and made presentations at that level so that resources and time could be allocated by the states towards the work of processing ratification of pending ALO instruments. One of the items that was adopted by these meetings was the tracking matrix for treaty ratification. The matrix is a tool which enables the state and ourselves to understand what the progress is towards ratification. This information helps the organization also identify whether there are any particular needs that the states have to complete the process by identifying when the ratification process has reached certain key milestones, and of course, it also allows states that are not considering ratification at all to say so that resources can be efficiently allocated. Once the tracking matrix is received, we collate and aggregate the data. By the way, just to mention that this tracking matrix has been sent out to all states by your various regional directors to be filled in by the CAAs. So this data is aggregated, and this is just to illustrate how this tool can work. On this slide, one state, for example, indicated that they were not considering the ratification of the Beijing Convention and Protocol because they already had domestic legislation that covered those new offenses. Of course, in that case, that state, and like many other states that may have already modernized their national legislation, we would be happy to provide clarification. And in that particular case, we would be saying that it's not enough to have the best domestic legislation. The way these treaties work is that you need to become a party together with other states around the world because it's important for the provisions to have global reach, because as you know, many of these offenses may be committed in one part of the world, they may have an impact in another part of the world and victims in another part of the world. So you have to be party to a global treaty framework with other states in order to ensure that the crime is punished wherever in the world it originates or is executed or the offender is found. We've also held several events around the world, such as workshops and seminars to promote ratification in West Africa last year, as well as in Singapore and also in Europe. And states in other regions are also welcome to invite ICAO to arrange such an event for them in their regions. Last but not least, we have the international ALO course, which was launched in 2017 and is delivered in 7 modules over 5 days. It's an excellent introduction to aspects of international ALO, especially for people who are just joining the industry. There's a high turnover of people, and this course is good not just for lawyers but also for non-lawyers, and provides the competencies for them to support their organizations in the implementation of ALO. So in conclusion, I just wanted to say that we are all in this together, and the only question we would ask ourselves is, what can we do next to advance ratification in your states and around the world? So over to you, and thank you for listening to me.
Yes, thank you very much, Legal Officer Andrew Oplot, for the presentation. We have learned through the treaty-making process, as well as the international air law treaties, as well as actions for us to ponder upon the ratification. And now we would like to move on to the discussion where we'll be accepting some questions from the floor. We had some excellent presentations prepared by two gentlemen here on the stage. So if you have any questions regarding these two presentations, please raise your hand and we will deliver the mic to you. Is there any questions? Yes, I see a gentleman raising his hand at the corner wearing an eyeglass. So please deliver the mic to him. Yes. Before you address your question, please introduce yourself first.
안녕하세요. 저는 정종찬이라고 합니다.
Hello, I am Jung Jong-chan.
Question, let us have our gentlemen wear their interpretation device so that you'll be able to understand the questions. 네, 잠시 동시 통역기를 사용하신 뒤에 질문해
Please give a few moments to wear an earphone for simultaneous interpretation.
for English. And I guess we're set. 네, 이제 질문해 주시면 될 것 같습니다.
Please go ahead. So, well, I want to ask a question about the fundamental question about the functions of ICAO. Under the international aviation law, so there is a definition about the aircraft. But if you see the Article 2-1, there is an exception articles about the aircraft. They says that if there is any, there is a definition that which excludes the scope of aircraft, which cause reaction against the air, and then also about the air reaction against the surface and water space is excluded from the scope of the aircraft. So does it mean that the water space related reaction is defined under the IMO framework? So if we combine the land surface and water surface, well, they are considered identically. So when they are considered identically, that means that we may have the aircraft that flies over the land surface. So when it comes to winging aircraft, winging ground aircraft under the IMO, I was wondering if you are prepared to have the convention to support both of them, like winging aircraft.
To have some compact with regarding the flying vehicles or the UAM. Is there any gentleman who can address this question? Yes.
Yep, thank you. The question, of course, touches on definition of aircraft. And one of the remarkable things about the Chicago Convention is that although the word aircraft is used over 100 times, it is not defined. And that is probably with good reason and shows the remarkable foresight of the framers of the convention not to have defined this term, which could have been related to the state of technology at that time. So the fact that it was not defined has enabled the evolution of the definition to align to existing technology. So the definition that the gentleman who asked the question was referring to is found in an annex to the convention rather than the convention itself. And so if there are any potential issues that need to be taken care of regarding that definition, it can be achieved through an appropriate amendment to annex to annex 6 of the convention, annex 7, yeah, to annex 7 of the convention. And that is the forum at which such a matter could be taken care of, presented by the state, and it would be processed through the Air Navigation Bureau and the ANC. So the good news is that there is an avenue to do it much simpler than tackling an amendment to the convention itself. Thank you.
Yes, then let's move on to the next question. Is there anyone who has a question? Please do raise your hand and we will deliver the mic to you. We have also talked about the treaty-making process as well as some strategic opportunities that can be found at ICAO. So regarding all the things that has been shared throughout the two presentations, if there's any questions, please raise your hand and let us know. Maybe because this discussion ends and there's lunch, is maybe the people are going to take that opportunity to ask the question themselves personally. Is that so? I can see some nods. Well, if that's the case, why don't we call this day off and give the two gentlemen a big round of applause for their wonderful presentation. Thank you very much.